Hi. So hello and welcome to the H-1B visa reform for 2020 and the alternatives. This program is brought to you by the ABA Young Lawyer Division and its Immigration and Naturalization Law Committee. The Young Lawyer Division is the ABA's home for new attorneys, giving members tools to navigate the early years of a career, opportunities to network, and resources to grow skill sets. The YLD Immigration and Naturalization Committee is composed of two co-chairs, myself, Sarah Brunet, and Brittany Faith Thomas, who's going to be presenting the H-1B reform today. So I will be serving as your moderator. And to start, I think we're going to go through some light introductions. So Brittany Faith Thomas is a partner. Her law firm, Grant, Konvalinka and Harrison, is providing immigration services, I think broadly, whether it's employment, family, or other humanitarian relief. And I myself, Sarah Brunet, I practice in Los Angeles, and I concentrate on employment immigration. So Brittany, thank you so much for presenting the H-1B reform today. I'll let you start. If there is anything you want to say before we start, let me know.
All right, well, welcome. This is very, very cutting edge. The new H-1B registration system is still not yet live. So everything that's in this presentation is based on webinars presented by USCIS and through the liaison efforts of the American Immigration Lawyers Association. So
we don't really know exactly what's going to happen, but this is our best educated guess at this time.
Yeah, and I think we're pretty firm on it, but even in these webinars presented by USCIS, they were not doing live demonstrations. They were presenting screenshots of the registration system. So I have not seen the live version, but I've seen screenshots of every slide that every page that USCIS says is included. So,
and just for people that are tuning in today and may not know who USCIS or ALA are, can you just tell me who's USCIS and who's ALA?
USCIS is a agency that's part of the Department of Homeland Security, and they are charged with processing immigration petitions such as H-1B applications for employers. ALA is the American Immigration Lawyers Association. It is an association similar to the ABA and often partners with the ABA for immigration efforts.
Perfect. So USCIS, the immigration agency for the US government, and ALA, basically the Association of Immigration Lawyers in America. So I think everybody gets it. Go ahead.
All right. Well, I think it's important to start with what is an H-1B visa. So we had some questions, and an H-1B visa is the visa that is very, very popular for college graduates here in the US. It is a specialty occupation visa. So essentially it is to help employers find quality applicants who can fit specialized positions. So, you know, something that does not require a bachelor's degree would not qualify for an H-1B visa. Something like an accountant or an engineer would. Typically, the duration is 3 years, which can be extended to a maximum of 6 years. The employer petitions for the immigrant or alien. They're not technically an immigrant because this is a non-immigrant visa. A non-immigrant visa just means that it's a temporary visa and that it doesn't necessarily lead to a pathway to citizenship. Before the employer can apply, they have to make sure that they are not damaging the US workforce, which is very important. How they do that is that they attest on a labor condition application that the employment of the H-1B worker will not adversely affect the wages of similar US workers. So they're not allowed to pay an immigrant worker less than they would a US worker, and that is decided by typical wages in the area. So a wage for Chattanooga, Tennessee is going to be different than for Los Angeles. Sometimes it's not always what you think, and the Chattanooga position would actually hire pay more because there's so few people who could do that job. It's an interesting procedure. But they also have to, employers also have to provide notice to existing worker of their intention to hire an H-1B worker. So that is a very common type of visa, and because it's so common, there is an over demand for the supply. There's more demand than there is supply. The labor condition application is filed with the Department of Labor. This is important because you need to have the labor condition application approved and certified prior to filing your H-1B. That can take 5 to 10 business days, which we'll talk about later, may adversely affect some filings. And it's just something to be aware of if you've never filed an H-1B application. And so it's dealing with two different agencies with the government. The Department of Labor, which has to certify the wage, and then, as we talked about before, USCIS, which is the one that actually grants the visa. So this category was created in 1990. Congress sets the limit every year. The current annual statutory cap is 65,000 visas, with an additional 20,000 for foreign professionals with a master's degree or doctorate from a U.S. institution of higher learning. So there are less people who fit that category, so that can often be a more promising, your chances of being selected for the lottery go up if you have a U.S. master's degree or higher. Prior to this year, the first business day of April would commence the lottery system. So the fiscal year for immigration starts October 1st, and you're not allowed to file an H-1B petition more than 6 months in advance of the start date for the visa. So that 65,000 visas becomes available October 1st. So what they would do is they would essentially open up the lottery for 5 business days. So the first 5 business days in April, all of these employers had to submit their completed applications with USCIS. That meant that it had to have the labor condition application, it had to have all of their proof that they are an actual business, all the proof that the person actually qualifies, they had to submit all the fees, and all of that takes a lot of time and effort and attorney's fees. And so that probably detracted some people from applying because they did not know what their chances would be. 2 years ago, they would have done the lottery for the 65,000 visas first, and then anyone with a master's degree left over would be put in for the additional 20. Last year, they switched that, so they now run the lottery first for the master's degree, and then anyone who's left over from the master's degree goes into the general pot of 65,000 visas. That means that your chances of being selected if you have a U.S. master's degree went up slightly from what it would have been 2 years ago. But that is over. We are not doing that anymore. You no longer have to submit your entire application in order to be considered. While USCIS would not have charged you for your filing fees if you were not selected, you still would have pending checks out there until they return them, which could be as late as September or October. Now, there is a new registration system, which is a lot shorter. It is a process that only costs $10 per applicant for registration. And you have to submit, basically answer about 20 questions, which we're going to go over, and submit $10, and you have bought your lottery ticket for the H-1B lottery. The key dates. So if you are an attorney and you are assisting people with this process, you can go ahead and begin creating your My USCIS account now. All employers will also have to have a My USCIS account, but they are not able to actually start that account until February 24th. So March 1st, the actual registration period will begin at noon. Neither employers or representatives are allowed to begin drafting registrations until it actually opens. March 20th, the registration period will close. USCIS has been very clear that there is no preference to whether or not you submitted on March 1st or March 20th, that you have an equal chance of winning the lottery no matter what day you put it in. So but instead of having a 5-day period where you have to submit hundreds of pages of evidence along with a labor conditions application Now you have to answer about 20 questions and pay $10, and you have 20 days instead of 5. So it makes it a lot easier to submit more applications. March 31st is the date by which USCIS intends to notify selected registrants, and April 1st is going to be the earliest date that you can file a petition. Even if you found out, so USCIS has said that there's a chance that they'll be able to notify people as early as March 21st that they've been selected. If you have applied on March 22nd, your application would be rejected because it's more than 6 months before the October 1st fiscal year beginning.
Brittany, you said something about the registration being less burdensome. Do you expect the number of applications to go up?
Yes. So that is, I believe it's discussed later, but yes, I do expect that the number is going to go up. Right now, your chances if you don't have a U.S. master's degree is about 30% of being selected. We expect this to go down significantly. There are lots of companies who could essentially just get resumes from applicants and be able to submit numerous registrations for these people and then for the same position. And companies that have been known to do this in the past, even when it included doing the entire petition, were like Disney and Microsoft, and the big tech companies will do just because you only have a 30% chance. The chances of being selected with a U.S. master's degree is about 60%. That probably will go down some, but I don't think it's going to go down as much as the chances for someone with a bachelor's degree. So it is much less burdensome, and smaller businesses are going to be more likely to be able to apply. But because it's going to be easier for big companies and easier for small companies, it just means that there's going to be more applicants, and so the chances of selection are going to go down significantly.
Okay, well, I guess we'll discuss this for the alternatives just in case.
Yes.
And so right now about the registration form, can you tell us about this? Like, how is it looking?
Yeah. So based on the demonstrations, they're going to be using My USCIS, which is an online portal that is currently used. So I use it for all of my citizenship applications, but all of the applications that are currently used for it are for individuals. So there's going to be a new type of account that they are going to be opening, which is called H-1B registration, and that's what people will need to apply. So you can see this is from the presentation that USCIS did yesterday. So if you are an attorney, I've pointed that you're going to select I am a legal representative, and you can create your account that way, and you can do that today. If you are an employer wanting to apply for your H-1B registrant, or you're an attorney who's advising your employer to apply, because they will have to certify all of the information that you submit as an attorney, then they will select this new category, which is I am an H-1B registrant. And that, again, is not available until February 24th. So, based on the screenshot.
About the information that we need to register. Is it burdensome? Is it extensive?
Yeah, so that's what we have right now. So right now, the important information that they're asking for, this is the information they're asking for, period, not just important, is they're asking for the legal name of the prospective company, and then they're asking for the doing business name. So this is very important because USCIS has not been able to confirm that if there is something different. So like, for example, in the presentation they did last week, someone asked, okay, we're moving offices, and right now our office address is 123 Main Street, but we're moving to 456 South Street between now and when we would be filing the H-1B. Will that disqualify us? USCIS was not able to definitively say. So it is important that all of the information on the H-1B registration is exactly how it will appear on your H-1B application. So you need to have your legal name and your doing business name, the employer identification number. So what I would do for the legal name is that I would ask for a copy of the employer's EIN confirmation number from the IRS, and confirm that that is the legal name. And then I would also look on the state where they are doing business and see what the Secretary of State has listed as their doing business name, and just triple check that, because it could mean that they disqualify them for an H-1B if it doesn't match up.
Right. And I mean, as practicing attorney, we know that, I mean, many of my clients get it wrong. So triple check the sources with the names and the EIN.
Yes. And so they also need to have the primary U.S. Office address, and then the legal name, title, and contact information of the authorized signatory. If there is a choice between who could be the authorized signatory, you have to think that, like, if we're selected on April 1st, that you have 90 days after April 1st to submit your H-1B application, that you want to pick someone who's going to be here in 4 months. So you want to make sure that you're choosing an employee as a signatory who is a long-term fit, because if you change the signatory, there's a chance that that could make it, that discrepancy could make it so the application is rejected. Lots of things to plan ahead for. And then on the beneficiary information, they need to know the beneficiary's legal name, their gender, date of birth. One interesting thing that has changed, and this is partly through AILA liaisoning, is that people are going to graduate in May. So there is technically a possibility that a beneficiary could not currently have a U.S. master's degree, but they will by the time their H-1B petition is filed in May. And so USCIS is allowing anyone who will have a U.S. master's degree after, prior to the actual filing of the petition, to go ahead and qualify for the master's lottery, which is a huge benefit for those people who are currently about to graduate with a master's degree. That greatly increases their chances of selection. You need to know the beneficiary's country of birth and the country of citizenship, and that is different. My husband, when I was practicing this last night, he joked, he goes, "That's me. I was born in Spain, but I'm a U.S. citizen." So just because someone was born in a country does not necessarily mean that that's their country of citizenship. And you also need to have their passport number. The authorized signatory will be required to certify under penalty of perjury that they've reviewed the registration and that everything is complete. So if there is something incorrect, USCIS has made a very, very severe statement, which makes me nervous about possible discrepancies. An LCA, like I said before, is not required to register. However, for me, I am going to go ahead and do a draft labor condition application for my clients, because I've seen it in the past where someone wants to file an H-1B petition, but then they don't realize how expensive it is to the wage that's required. So this can be a problem, especially with private schools, is that teachers can be, the prevailing wage or the wage on the labor condition application is higher than what a private school can pay. And I don't want to waste anyone's time going through this whole process of filing for the H-1B registration if at the end of the day they're not going to be able to afford the employee that they're applying for. So I'm going ahead and drafting those, and that way they'll be ready to file if the application is selected. Some attorneys are going ahead and submitting them so that the LCA is ready if they're selected. So during the registration period, USCIS will permit users to edit as many times as they want. However, once you submit it, then you can no longer edit it. You can delete something that has been submitted and submit it and make a new registration. However, once it's submitted, you cannot edit it from that point forward. So it's important to make sure all the information is fully correct. You're only going to lose $10, but if you're doing this on the 19th and you find out on the 21st that something was incorrect, then you're out of luck. So, as we talked about before, there are going to be a lot of employers who want to file for more applications than they normally would. Whenever you do anything in bulk, you often will accidentally duplicate. USCIS is going to delete all registrations where the same beneficiary has been registered twice or more. So if you accidentally submit, if you're doing, let's say, 50 applications and you accidentally type someone in twice, then USCIS will delete both submissions. That person will not even be, it's not that they delete the second submission, they delete both of them. So it's very important not to duplicate. I'm going to go to the next slide and show you how to look for that. But just note to make sure of that. The system will allow employers to submit up to 250 registrations at the same time. So you can batch 250 and then submit them, but there is actually no overall limit. So if the maximum is 250, you can tell that they're prepared for some of these large corporations to submit, you know, over 250 applications or registrations. Let me go. So I'll go back to that slide, but this is where I'm saying that you can check for duplicates. So whenever you have a list of your clients that have been submitted, it will actually allow you to export that into an Excel, and you can use the Excel to sort your beneficiaries. And if you sort your beneficiaries, you can tell if there are any duplicates. And you probably just want to, as a best practice, do that to make sure that you don't have any duplicates and that you address that prior to March 20th. Because if that is discovered after March 20th, then you're out of luck until next year. So, syncing attorney and client profiles. There was a webinar on this yesterday with USCIS. If you have not used the My USCIS system, so it's going to be very similar to what I do when I have someone for a citizenship application. If you haven't done that, the webinar that USCIS presented for attorneys yesterday will be available, they said probably by next week, on the My USCIS YouTube page. So you probably want to check that out. They did not go into a whole lot of detail on some of the other things that we're talking about, but they did talk a lot about how to sync it. So attorneys will be able to draft the submissions along with their G28, which is the notice of appearance of attorney, and then they will send it to the client to review and approve. And then the clients will approve the drafts and the submissions will be sent back to the attorney. The attorney will then pay the fee or fees, depending on the number of applications, and finalize the actual submission. And then on both portals, the attorney and the client, it'll show this next page that has the list of clients. It is highly recommended that this process where the client is approving either be completed with the client in your office or at their office, or at least on a conference call, because there's a lot of different steps going back and forth and making sure that they have your attorney passcode, because there's a number that USCIS gives you to give to them to sync the accounts. And it's just a whole lot easier to do when you're both doing it at the same time than your client trying to do it while you're in a meeting and then getting a million emails. Oh, did this work? And then going back and forth. It'll be much more efficient if you either schedule a time to meet in person or at least on a conference call. Payment, as I discussed, if you're using an attorney, the attorney will pay. If you're not using an attorney, then the employer can pay. The USCIS website will automatically prompt you to go to the pay.gov portal, which is run through the US Treasury. And that registration system will permit payments from a bank account, credit card, or debit card. No cash, no money orders, none of that. So you can either route it from your bank account or use some form of card. The registration system will allow for batch payments. So if you're doing 250, then you'll pay 2,500. If you're batching your registrations. If for some reason you need to split them up, like let's say that you have branches of different companies and the logistics branch and the engineering branch or need to subscribe this to their individual budgets, then you can pay individually, but you need to see that about in your batching system as well. Lottery results. So you should receive an email if you're selected on the at the time that you are selected, and that will include a PDF that will be your notice of selection, which USCIS has said needs to be on top of your H-1B petition whenever you're ready to file. So on top of the forms, on top of the payment, the first thing they want to see whenever you mail your actual H-1B petition is that notice of selection. On your My USCIS account, which I'm sure a lot of your clients will want to go in and look, or if you're an employer, don't want to go in and look yourself, there will be 3 things that you'll see at first. So everyone is going to show submitted as soon as you submit your H-1B registration. If the lottery is run and you're not selected, it will continue to show submitted because they are going to be holding those applications in the event that they do not use up all of the applications that are accepted are not used. So that is great news. In the past, they've just run the lottery with a little bit of slush for people who either don't want to apply or they get denied. But by holding these on a wait list, it allows for 100% of the H-1B visa numbers to be used, which they haven't been the past couple of years, just because, number one, there's been an increase in denials of H-1Bs, but also just because, some people withdraw their application. So if they are selected, it'll show selected to file a 2021 H-1B cap subject petition. Not selected will be once they complete the entire process, then it'll show not selected, and that's when you know that there's no chance any longer that you're going to get off this wait list, and you can move forward. If you haven't already been thinking about your H-1B alternatives, you can have that serious conversation with the employee. Denied is going to be in the situations where the registrant or representative submitted more than one registration on the beneficiary's behalf. So all registrations, all duplicate registrations are going to be deemed invalid, and so that will show up as denied no later than March 31st. Unfortunately, there is no appeals process. USCIS says this is because it is a tool and not a form or petition. So whatever happens, if you do get denied and you don't think it was duplicative, there's no way to appeal. So it is very important to be very, very, very detail-oriented at the beginning. We already talked about the waitlist process. We don't know exactly how that's going to work. We don't know whether or not they're going to just run the lottery and give everyone a place in line at the beginning, or they're going to run it for the lottery numbers and then rerun the lottery anytime that they have additional petitions. We don't know if there's any sort of preference for master's cases. We just don't know. It's part of the fun. When can selected employers apply? They can begin applying April 1st if it's a business day, which this year it is. It's a Wednesday. And they have 90 days from that April 1st to apply. If they are like a wait list and they find out May 1st that they were selected, then they have 90 days from the date of selection. So it's 90 days after that May 1st date. Again, the selection notice needs to be placed on top of the filing. So how long do employers have to file? They have 90 days. There is something, I think there's a slide on it in the future, but I'm just going to say it now. If your employee is currently on optional practical training, or CPT, conditional practical training, and their status expires prior to the 90 days, in order to get cap gap protection, which means that, like, let's say that their OPT status expires on May 15th, then if they have an application pending prior to May 15th, then they are protected between May 15th and October 1st, and they do not have to leave the United States. If an application is not filed before May 15th, then their OPT status will expire and they'll have to leave, and they can re-enter once their H-1B petition is approved, but they'll have to consular process to get their visa to come back in. That's a pain. People want to avoid that. So your real deadline to file, if you're applying for someone who's in OPT or CPT status, is to file prior to that status expiring. In that case, then they get this cap gap extension, which allows them to remain in the United States and continue to work for the employer. We do not know if premium processing will be available. The past couple of years, they have suspended premium processing because they say that they have too many applications to process. Essentially what premium processing is, for those of you who don't know, is that you pay an additional $14.40 in filing fees, and USCIS promises to process your application within 15 days. So it's pay to play, pay to be a little faster, but we do not know whether or not premium processing will be available. So this is the cap gap issue I was talking about. So it's just really important to be fully aware of every beneficiary's status and when that status expires. And if you do have someone who is going to have their status expire really soon after that April 1st date, it might be worth your time to go ahead and file a labor condition application and get the petition somewhat ready to file, depending on how quickly it is, and depending on whether or not your client wants to go forward with doing an entire petition, but have that ready to file so that you do not lose that cap gap protection. All right. So I've got
Alternative.
a
Yeah,
lot.
because we're expecting, obviously, people who have a master's degree to still have good chances. But like you said, people with bachelors may actually have lower chances. And even in the past, the, H-1B was not always guaranteed. So I think we want to touch on alternatives and see what is a holistic approach before jumping in and seeing if maybe there is an alternative right off the bat, or what is going to be the alternative in case we're not selected. So what do you think?
What do I think?
Yeah, what do you think? What are the good options? Like, how do we, do we talk to an employer? How do we talk to an employee about the alternatives? Do we bring it, up right away? Do we like,
Think it depends on the I think it depends on the employer.
mhm,
Sometimes it's going to be obvious that there's an option. So like let's say it's an international company and the employee is from the company where they have another office. You're immediately going to think, oh, maybe an L1 for intercompany transferee is going to be easier. So I
mhm.
think that it's, you know, really issue spotting based on the client, but it's important just to tell them up front every time is that, kind of what the statistics are, and that the statistics of winning the lottery are only going to go down. The
Right.
benefit this year is that they're going to spend a whole lot less money figuring out whether or not a whole lot less money in fees and attorney's fees figuring out whether or not they win the lottery at all. So it'll be much less burdensome this year.
All right. So,
So some employers are going to be cap exempt. So if it's an institution of higher education or related to an institution of higher education nonprofit entity, or a nonprofit research organization or governmental research organization, then they are cap exempt. Sometimes, even if the actual H-1B employer is not cap exempt, if they have someone who's working in a facility, they could be considered cap exempt. So let's say that you have an engineer who is working for a private company, but they're actually subcontracting out to a governmental research organization, then they might qualify to be cap exempt, which means that they don't have to go through this lottery process at all, because the cap, if I haven't made it clear, is that 85,000 capped visas, but they might actually be able to get around it. So it's important to ask your clients at the very beginning what kind of employer they are, and then also uh, where the employee will actually be working.
so O1 and P1s are an option that can be great. O1s rather than P1s. P1s tend to be more industry oriented. So unless you're in the entertainment field or the sports, um, I guess a P would most likely not be an option. But O1s are very broad. Uh, they cover a broad industry. So people in business, people in science, and the entertainment industry can be covered, including education. So as long as you have someone who really would be kind of the cream of the cream, people with extraordinary ability in business or in science, in athletic and education, are people who have extraordinary achievements for TV, or just people that are renowned for the arts. That might be an option. And you have to be somewhat holistic when you look at the employee's background. You could have someone who's in marketing, and you would think marketing is business, but let's say this person is really more a creative, then you most likely have an artist, and you have someone who has a standard to get a no one who's lower. They just have um, to be renowned in their field. So I think a no one is usually a good option if you have someone who has a very specific background, who's very at the top of their field. And also, although I don't fully agree with this all the time, but getting an O1 may somewhat lead you to an EB1, which is a green card based on your extraordinary talent. It's not, it's not a guarantee, but this is a pathway where you know that you already kind of make the cut.
As I talked briefly about a second ago, an L1 intercompany transferee is for international companies who have a U.S. office and an international office. So, for example, Volkswagen here in Chattanooga has international offices in Germany and Mexico, and they use L1s for those company employees. So it might be worth it for them. You do have to have worked for the employer abroad for a year. So it might be worth it for someone in that type of situation to send the employee abroad to work in the abroad office for a year and then apply for an L1 visa because you're not going to deal with the cap issues. And you'll also be able to have the employee really learn their company from outside the United States, and then have them bring that so that the international offices are, somewhat standardized. So there's definitely a benefit to that. Family members are entitled to work on L2 status, so that can be a big benefit for employees who are married and have spouses who want to work.
So one option that people often overlook are J1 visas. Most people think that J1s are just for trainees or interns, but actually the J1 program is really broad, and you have a program for physicians, for professors, for research scholars, and for specialists, for instance, or actually also teachers. And I think it's a program that might be a little bit more forgiving in terms of wages as well. And it does come with some strings attached, some programs, and based on the skills and the country, may require the person to leave the US for 2 years and go back home before even returning to the US. But basically, it does come with strings attached, but it's a program that really should be considered when you have an applicant. Would they qualify for a J1? Because it's usually um, a pretty easy solution to put in place.
Another option that's available for Canadians and Mexicans is possibly to qualify for TN professional status. So that was originally part of NAFTA, but it's now part of the new NAFTA deal. So for there's a list of occupations, and the people who have a job that's on that list, if they're from Canada or Mexico, they can apply to work in the United States. So it is really easy for Canadians because they don't even have to file their petition with USCIS. They can file at the border and just bring their packet at the border, and the Customs and Border Patrol officer approves it, and that can be approved indefinitely. And it makes it really easy to travel back and forth. Mexico's a little harder. You have to file your petition with USCIS, which can take longer, but pre-em processing is available. So that is definitely something to look for employees who are Canadian or Mexican.
So E1 and E2s are also very interesting options. So an E1 or an E2 will allow the foreign national of a certain country to apply for a work visa. And for instance, what happens is the US company would be owned at least 50% by citizens of, let's say, France. So for instance, I have a company, a software company here in the US, and it's owned 50% by French nationals. It doesn't just have to be one person. And depending on the structure and the activity, we may be able to process an E1 or an E2. An E1 is based on the trade between the US and that said country. So for instance, let's say I distribute clothing and I always import from France and resell, and I have all these this trade between France and the US to a certain volume. I may be able to bring in French workers to work for me in that context. Or an E2, which would be an investor type of visa. Let's say I come into the US and I invest in a restaurant, and I am at least this is a company that is at least owned by French nationals at 50%, I may be able to bring French chefs or a French, like anything basically, as long as they are people who have certain skills. It can't just be nobody, but that's a facilitated process, but it's really based on the citizenship, and actually we'll have a full webinar about this.
Yes, I believe that's scheduled for either April or May. So.
Right.
So I talked before about OPT or CPT. So if you are applying for someone who is currently in college, then OPT or CPT would be a good alternative to gain them another year at least. If they're already in OPT or CPT status, then some STEM degrees, you can get actually 2 years of status. So I would highly advise, if you do have someone in a STEM degree, to go ahead and apply in the lottery the first year. That way you get 2 bites of the apple. You get to buy 2 lottery tickets for the same person. But you definitely want to be aware of where people are in their educational programs. So OPT is actually applied through the university. The employer will work with the university to make sure that all of the paperwork is completed, but it is not something that typically the employer applies for with USCIS. It's an extension of the student's underlying F1 visa, which is F1 is student visa. So something that might be very attractive for someone, especially on STEM OPT, is to go ahead and file for the green card directly. So H-1B often leads to what's called the PERM process, which is for people who have a specialty occupation can get their green card through their employment. That process is much more rigorous than an H-1B. The employer has to advertise to U.S. workers for the position, and the employer has to, certify this with the Department of Labor beyond just the prevailing wage. So they have to certify the wage like they do with the labor conditions application through a prevailing wage application, but they also have to do this rigorous advertising process, and small errors in the advertising process can lead to a denial. And additionally, if there is a U.S. worker who is qualified, then that automatically ends the process, because the U.S. worker would have to be hired over the foreign worker. So it's a high risk, high reward system. But if you have someone, and it also takes a while. So if you have someone who is in a 2-year STEM OPT and you're certain that you want to hire this person, or the employer is certain that they want to hire this person, it might be worth going ahead and starting this process. Even if they don't have their H-1B status approved, that you can still apply for the lottery while you're advertising and going through the PERM process, but you could be doing this so that at the end of that 2 years, they might even be able to stay in the United States with their green card. Unfortunately, this is not going to be an option or a good option for people who are from China or India, because there is a statutory limit on the number of visas available. High traffic countries, countries that have a lot of demand, have a waiting list. So right now, for someone with a U.S. master's degree applying for their green card through this process, if they were from India, the priority date is May 19th, 2009, and for China is July 15th, 2015. So that is a long wait, and an employer is not going to really want to wait that long. What's nice is that if you do have an H-1B, whenever you're going through this process, that you can extend that H-1B while you're waiting on your priority date to become current. If you don't have an H-1B, though, the employee would have to go back to their home country or come in on some sort of other visa, which could be an L1, could be things like that, but probably not as viable for someone from China or India. Priority dates are current for every other country, except for if you only have a bachelor's degree. The Philippines also has a wait from June 1st, 2018. I happen to have the visa priority bulletin on my wall. That's how often I deal with these numbers. So, but if it's someone from, England or Canada or Mexico or things like that, they might want to just go ahead and file for the green card directly and still be applying for the H-1B lottery, but have that in process. I think those are the main alternatives. There's obviously, every case is different, and then an employee beneficiary could have a U.S. citizen spouse or something like that, and that would be something that would be independent of employment. But for the employment alternatives, what we've outlined are pretty much the most common ways, other than H-1B to be in the United States.
Okay, so I think we had some questions. The first, the first that we had gotten was what are the elements, forms, and info that are required for this new lottery? So I believe, covered this. And then would it be possible to fill petitions for several applicants for the same position? So I think we kind of covered this, but would you like to respond to this very clearly,
Yeah,
Brittany?
so yes, so they can apply for several applicants for the same position. If for some reason the employer applies for 10 people for one position and 2 people are selected, then they would just pick which person they would like to move forward on. And that would be one of those situations where then they would have to notify USCIS that they don't intend to move forward on the second application, and that would mean that there's a visa that goes back in the pot, which hopefully will go to someone on the wait list.
Nice. Okay. And then any suggestion as how to obtain immigration status to open a solo practice by a foreign attorney licensed in the US? So that's probably someone who's part of the YLD. So to open a solo practice by a foreign attorney licensed in the US, I'm not sure the H-1B would be a solution because you would pretty much self-sponsor. I think you agree to this, Brittany. But I would say depending on the country of citizenship, an E2 might be an option. So an E2 would allow people from certain countries, people that have a signed treaty with the US, to invest in the US and basically grow a business. I would say an E2 is probably a viable option. Other than that, to open a solo practice for someone in the US, I don't have any other ideas. Would you have any, Brittany?
No, I mean, I guess if they have a practice abroad, that they could do an L1 starting a new office.
That's true. That's true. That would
Um,
be.
but that would mean that they'd have to show that they actually have, an office abroad. So a recent law grad would not qualify.
Right. Yeah, no, that's, and an L1 is not easy.
No.
And so I personally, if I have the choice, I'd much rather go for an E2 than an L1. And then I had another question. What does one do if their H-1B application renewal is not accepted? Is leaving the country the only option? So I think that's a very broad question, and that would be a question that would be much better addressed in basically in a consultation with that person, because we may have options and we may not have options. So what would you say?
I would agree. I mean, we went over some of the major alternatives. I would issue spot the case and see if any of those other alternatives work, and then consult an immigration attorney prior to just leaving, because one thing is, like, once you're gone, it's a lot harder to get back in than it is to change your status here in the United States.
Yeah. One other question that we had was basically on H-1B, is someone also allowed to do business on their own in addition of working for the employer? And that's something that needs to be covered extensively, because I've ran into that issue with many clients. What's the answer? It's no. I think people will try to make little compromises with themselves and be like, well, I can sell on eBay, so basically I can have a little gig on the side Selling your shoes on eBay is very different from working for
And what the
somebody.
employer is petitioning for is that you are, the beneficiary is getting a full-time job with them. So,
Right.
their efforts are supposed to be with the employer. We have a couple of questions on the chat I'm seeing.
Yes.
So one that I see is, I don't understand talking about the G28 and the conference call with the employer. We're not submitting G28s, are we? Yes. So if you are drafting the registration through the My USCIS portal and you are not the employer, then you must complete a G28, and the employer must sign your G28 in order for you to submit the application on their behalf. So yes, so if you're syncing your application, you're syncing your accounts with the employer in order to be able to do the applications for them, then yes, you have to fill out a G28. So the employer is, whenever you finish your drafts, the employer is reviewing not only your draft of the registration, but also your G28 and signing your G28, allowing you to submit it on your behalf. So if you're an employer and you're applying for yourself, you don't have to do that. But if you're registering as the attorney, then you have to submit the G28. I suppose that you could just help the employer and log in with their system. If you haven't logged in with the My USCIS system, you'll know that they require two-step authentication, which means a text message or an email with a code every time you log in. So it's hard to just be able to do that as the attorney without registering. But you theoretically could do that, but you would not receive notification whether or not the application was accepted if you're not the registered attorney on it.
So we had a few questions about spouses of H-1Bs being able to work. Would you like to answer this?
So spouses can get an H-4, and there's a lot of different categories of those, but generally H-4s cannot work if it's just an H-1B. However, if someone has approved I-140, sometimes they can work. So it just depends on what status their H-1B visa is in and whether or not they're applying for a PERM and how long they've been in H-1B status. But so that's not, it's more extensive than being able to answer yes or no. And that would be something that you would need to talk to about with your immigration attorney.
For sure. What else? Do we have any? Is the family-based green card and the H-1B PERM process still two different paths? Yes, an H-1B and a PERM process are two different paths fully. An H-1B is a non-immigrant visa, and a PERM process will lead to a green card. We have questions regarding fees. So we're not allowed to discuss certain set prices, but I do think that the way attorneys are going to approach the fee is going to be different. For instance, in my practice, I've implemented a lot of hourly billing. I know that it's not always the preferred setting for immigration attorneys, but I find that many of my clients respond really well and they know like in details exactly what I've done at all time. So my clients don't think that I'm just charging them for things that didn't, require anything. And I think that for me, being able to be flexible with my time allows for just a really good detailed work. And also my clients tend to be really on top of everything because they know that if I'm just calling them to remind them of something, they're paying for this. So I mean, I'm sure the structure is going to change, but I think one way to not be in the red as a practitioner is to go for hourly billing and just set the expectation with your clients that you're a trustworthy practitioner.
And I agree with that. I have a lot of hourly billing, but I will say that for this process, I have a set fee for the registration per client and to do a draft LCA. And then I have a set fee if we're selected. And it's based on the number of hours I think I'm going to work on it. So I have set that fee at 4 hours per client. So it is a flat fee based on 4 hours. If for whatever reason after this year I realize that the actual amount of work that I put in is 8 hours, then I will increase my flat fee. But I do think that it, especially for my big clients, I have several clients where I'm going to be doing multiple applications or registration. And for them, it's nice to be able to say, okay, it's going to be 4 hours of time per person. Do we want to petition for this person? More than just, oh, how many hours do you think it's going to be? And again, because it's brand new, I don't know for sure that 4 hours is what it's going to be. So maybe you're smarter to be doing it hourly. But it's just, that's what I'm playing around with for this first year.
Yeah, and I think, I think we have practitioners that are listening, and billing hourly or billing flat fee is just, something that could be also covered in a webinar, but at the end of the day, you have to realize that you're providing a service, you're selling your time and your expertise, and we tend to almost gamble with our time, and we always think that it's going to take less time. But when you really look at your hourly, you tend to see that you actually spend a lot of time working. I mean, at least on my end. So I think it's very important to not sell yourself short, and really take everything into account, especially when you don't exactly know what the process is going to be like. But we understand that clients also have expectations, and they want to make sure that they're not going to spend too much money. So it's complicated to make the best of the billing system. We have another question. What is the advantage for clients to have an attorney applying for them instead of doing the process on their own now that the process is so simple? I think it's a really fair question, because almost like the first part is somewhat simple. It could lead to people thinking that they can fully do it on their own. It's technically an administrative process that people should be able to do on their own. At the end of the day, it's a process that is also very complicated for attorneys. People don't just jump into doing H-1Bs, they're trained. And technically, I would say there is definitely a value usually, to having someone. Also, one thing is if you are selected and you don't have an attorney lined up, it may not be that easy to find somebody in your time frame to to do your application. I don't know, Brittany, what would you think? What would you say?
So I think the benefit that I'm bringing with my clients is doing the draft LCA and making sure that the job title that they're applying for is something that actually qualifies for H-1B. So like I have a third-party logistics company, and technically a supply chain manager, it's a 96% of people have a bachelor's degree or higher, but USCIS doesn't automatically say that that's a specialty occupation, and you have to argue it. So, but if the person is doing mainly industrial engineering in that job, which industrial engineering and supply chain manager are very, very similar positions, then I'm advising my clients, if that's what their duties are and they have an industrial engineering degree, to apply as an industrial engineer versus a supply chain manager. And that's something that an attorney knows is a lot easier for USCIS to approve, because industrial engineering is recognized as a job zone 5, where supply chain manager is a job zone 4, which that's just a fancy way to say we know it requires a bachelor's degree. So that's an expertise that you're going to have to disclose to USCIS whenever you file. And if you disclose it and you pick the wrong job title, it can lead to a lot more RFE chances and a lot more RFEs, request for evidence, and a lot more headache on the back end, where if you consult with an attorney and make sure that you're applying for something that is the correct job title with the correct specifications, you're going to save a lot of time and money on the front end.
Right. And I think, we have another question. What's, what value do attorneys add? And I think it's a fair question. I think a lot of people go into, the process thinking that, you just go through, basically, and send your resume and send the job description, and this is going to be it. At the end of the day, there is a lot of you curate the whole strategy to make sure that this is going to go through. And I think a keen and expert eye can really help in the process. Unfortunately, that's a value that you can't fully measure because at the end of the day, you either get your visa or you don't get it, and you'll never know what would be the outcome with or without an attorney. So I think we've reached an hour webinar. Was there one last question that you wanted to cover?
I think we've gone through most of them. There are some questions just about the system. And what I would say is if you are an attorney and you're planning on applying, to go ahead and open your system, open your account now and play around with it, and advise your employers to go ahead and open on February 24th and play around with it. So that way, whenever you're actually able to enter in your registration on March 1st, you are both familiar with the system and you're not trying to figure everything out from scratch, because I know that is very stressful that first time. Also, March 1st is a Sunday. If you're just planning your time, it's a Sunday. It'll open up around noon. So if you work on Sundays, you can go in and do it. Otherwise, you can start really putting in your registrations on March 2nd. And I think you're going to see a lot more information. It's going to be a lot more useful to actually go into the system. But there are screenshots available on the USCIS YouTube and through AILA if you're an AILA member. And believe even some of that information is available to the public.
Great. Well, thank you so much. We'll be doing a few webinars in the future. So we'll be announcing the webinars, and Brittany and I will be participating. We hope that you enjoyed this webinar. If you have any follow-up questions, you can reach out to us. You have our names. And yes, thank you so much.
Thank you.